Ajita, start.
Yes, ma'am. A very good afternoon to one and all present here in this Google Meet and also in the YouTube Live. It gives me so much pleasure to see you all here in this day to discuss about a very interesting topic, especially for the commerce organization. The topic for today is intellectual property rights, IPR, a promising field for the commerce skill. So today is also another important day. It's March 22nd and it's called as World Water Day. So for this year 2021, the United Nations have declared the theme for today's Water Day is valuing water. We all use water every day, but how much are we oblivious of the value of water? The value of price of it's not always the same as how much we're using. Water is always the fundamentals of whatever we're doing. So we need to value it whenever we use it. So I hope we all conserve and use the water as as in a conservative way, and whatever our actions should be aligned, and it should not destruct the natural resources. We should be grateful for that. So let's all conserve water. Let's all say big thanks for the water which is available here and now. So,
Ajita, excuse me, sorry. Amrita ma'am, can you mute your phone? Mute your system, please.
Yes, sorry. So yes, with this positive note, let's dive into this informative topic today, which is intellectual property rights. And now I request Amuda ma'am and Vinodini to render our college prayer.
शुभ कर मन ते कब हो न टरूं देश वावर मोए शुभ कर मन ते कब हो न टरूं अरे सो जब जाए लरूं निश्चय कर अपनी जीत करूं निश्चय कर अपनी जीत करूं निश्चय कर अपनी जीत करूं देश वावर मोए शुभ कर मन ते कब हो न डरूं अरे सिख हो अपने ही मन को अरे सिख हो अपने ही मन को लालच हो गुण तो चुरो लालच हो गुण तो चुरो लालच हो गुण तो चुरो देश वावर मोए शुभ कर मन ते कब हो न टरूं जब आव की औद निदान बने जब आव की औद निदान बने अत हिरण मैं तब जूझ मरूं अत हिरण मैं तब जूझ मरूं देश वावर मोए शुभ कर मन ते कब हो न डरूं देश वावर मोए शुभ कर मन ते कब हो न डरूं शुभ कर मन ते कब हो न डरूं शुभ कर मन ते कब हो न डरूं.
Thank you so much, Vinodini. So it's time to know more about our resource person for today's session. So now I request Dr. Gayatri Harikumar ma'am, Head of the Department of Accounting Finance, to give her introduction about the resource person for today.
Yeah, good afternoon to everyone present here. I'm really honored and feel privileged to introduce Dr. M. Mahendra Kumar to the audience here because he's one of our Guru Nanak College family member, faculty member, and I'm really happy that he has accepted to be the chief guest for today and deliver his address on IPR, that is Intellectual Property Rights, a promising field for the Commerce Guild. To Sir C.V. Ran's to read this, but I'm putting it in a nutshell and I will introduce very briefly to the audience here. Dr. M. Mahendra Kumar is working as an assistant professor in the Department of Biotechnology, Guru Nanak College from June 2017 till date. Prior to his teaching career, he was working as a R&D manager at Chennai Biotechnologies in R2 Salem from 2009 to 2014. He studied his BSc Plant Biology and Plant Biotechnology at the New College, Chennai. He has done his diploma in Medical Laboratory Technology with distinction. He completed his MSc Biotechnology degree with a university rank and was a gold medalist, passing out in flying colors from Wheeltech group of institutions. He cleared the Tamil Nadu State Eligibility Test, that is TNSET, conducted by the Government of Tamil Nadu in 2016. He had completed his postgraduate diploma in Intellectual Property Law from Tamil Nadu Dr. Ambedkar Law University, Chennai. He has done his PhD from the University of Madras in Ethnopharmacology on scrutiny of plants of Palani Hills, Kodaikanal, for their bioactive compounds and their bioefficacy against inflammation, cancer, and diabetes. He had been awarded with Dr. APJ Abdul Kalam Award for Young Scientist in 2018 by Biologists Forum India. He got selected to attend a workshop on metabolomics at the National University of Singapore during his doctoral studies in 2014, and he also received a travel grant to travel to Singapore. He had presented a research paper on his research findings at the 4th International Conference on Biosciences and Biotechnology held at Kuala Lumpur, Malaysia in 2019. He has been invited as a judge and resource person for various academic and scientific programs across the country. He has organized various conferences, workshops, and seminars in various administrative capacities. During his post-graduation study period, he received the Best Paper Award in a national conference on recent advances in bioengineering organized by the SRM University in 2008. He received the Best Poster Award at the National Conference on New Frontiers and Current Trends in Biotechnology, organized by the University of Madras and Society of Biotechnologists, India. He has published 7 research papers which carries a high impact factor and got indexed in Scopus and Web of Science. He has 5 GenBank submissions to his credit. He is a life member in many reputed scientific associations and societies. To name a few, he is a member of the following associations: Society for Medicinal Plant and Natural Product Research, Germany. He has given a name in German. I'm just skipping that. Organization for Industrial, Spiritual and Cultural Advancement, OISCA, Tokyo, Japan. He is also the member of the National Environmental Science Academy, New Delhi, India. He is the member of the Chemical Biology Society, CSIR, Indian Institute of Chemical Biology, Kolkata. He is a member of the Society for Biotechnologists, India, Virginia University, Kerala. He is a member of the National Academy of Biological Sciences, Center for Advanced Studies in Botany, University of Madras, Chennai, India. These are very proud achievements of Dr. Mahendra Kumar, and because it's so much connected to biotechnology, we are not able to assess the impact, or we are not able to gauge your profile, sir. So I request you to kindly make your talk more interactive so that we commerce students who don't have much connectivity with science can understand better and also acquire a few patents from our side in the commerce field. So I think you have skipped your, I think you are the only person in Guru Nanak College to have a patent, I suppose. So you can tell about that process also to our students so that they are also more inspired and they will hunt into this field and also acquire more laurels and patents to their credit. So we require you, or request you to take the forum, and I hand over the mic to Ajita. She will officially give the mic to you, pass on the mic to you. Thank you, sir.
Yes,
Thank you for accepting our invitation and gracing the occasion.
Yes, thank you, Mom. Thank you for the elaborated achievements of Dr. Mahindran sir. Today, I'm very much so excited to be here to hear from you from your practical experience about the patent rights and everything. Of course, everybody are excited too. So, thank you so much for being here, sir. And now I request you to take over the session. And yes, sir. Thank you.
Yeah, thank you, Ajita. And I especially thank Dr. Gayatri Harikumar, Head Department of BCom Accounting and Finance, for giving me an opportunity to share my views and my knowledge about IPR to my dear friends. Is my screen visible?
Yes, sir, it is.
Yeah, thank you. So, formally, I welcome you all to this national webinar on intellectual property rights, promising field for the Commerce Guild, organized by the Department of BCom Accounting and Finance, Guru Nanak College. Before going to IPR or to my presentation, I would just would like to tell you this IPR is not something that is more exclusive to science. IPR is a field where anyone can succeed or anyone can acquire. Before that, a property is something which is which someone take possession of, or which is belonging to someone, or the possession someone has. And this property is of two types: tangible and intangible. Tangible means literally meaning touch, which could be touched. The property that have a physical existence, which can be easily liquidated, but it is depreciable. Example, the cash we have, furniture, vehicles, building, machinery, etc. There's another property called intangible property. And intangible property is an asset that does not have any physical existence, but you cannot touch or feel them, but they have current and very good future value. Example, the goodwill of an institution, intellectual property, the customer data of a company. Intellectual property is a kind, or more importantly, type of intangible property. This results from the creation of human intellect in industrial, scientific, literary, or artistic field. The IPR, the intellectual property rights, are the exclusive rights granted to the creators or are the owners of works that are the result of their sheer hard work and human intellectual creativity. IPRs can be used by the owner for commercial exploitation, subject to the provisions of the national and international agreements from time to time in force. What are the types of IPRs we have? We have patents, we have trademarks, industrial designs, plant varieties, copyrights, geographical indications, layout design of integrated circuit, and confidential information. One could, astonish if they come to know that one product may have so many IPRs with itself. For an example, a phone, the data processing methods, operating systems, the operation of the user interface belongs to patent. The softwares used in the phone, the user manuals, ringtones, startup tone, images that comes inbuilt with the phone comes under copyright. And some technical know-how which is kept in-house and not published, like Alexa, Siri of the phones, those are called trade secrets. And the overall look of the phone, the arrangements and shape of the button, the position and shape of the screen belongs to design. And finally, the name, the brand name, that comes under trademarks. Out of the IPRs, so many IPRs have mentioned, few need to be mandatorily registered and few need not. Patents, industrial designs, geographical indications are IPRs that are to be registered mandatorily if you want to protect your IPR. Whereas trademark and copyright are not necessary. In India, the intellectual property law are governed by these 5 acts. First, in 1957, the Copyright Act was enacted to protect the artistic work, literary work, audio, video records, and software, which is very recently amended in 2012. Then the Patent Act 1970, which is amended time to time. The latest amendment is in 2015, which governs the entire processing of patents. Then Trademarks Act 1999 deals with trademarks, brand, property, marks, etc. Then Geographical Indications Act 1999, which governs the geographical indication of the country. Then we have the Industrial Designs Act 2000, which deals with the industrial designs. Since you're all commerce, I've given preference to trademark. The trademark are symbols, words legally registered or established by use of representing a company or a product. These trademarks distinguish the goods, services in the marketplace from one company to the other company, that is their brand name and logos. They can be used as marketing tools so that customers can easily recognize a particular service or a product of a company. It gives protection on the basis of, since trademark are not mandatorily registered everywhere, the protection is given on the basis of first adoption, who first adopted it, then who's the first user. If there is an inventor for the trademark or the business, who's the first inventor? In first invention, adoption, user is more superior than the registration. If you want to register a particular business mark or logo for a trademark, then that logo or brand name should be distinctive, not be deceptive, should not be descriptive, and it should not belong to any exclusions provided by the law. And finally, it should be in conformity with public order and morality. What are the main functions? If you register some mark as, why should I register? If you register, then these trademarks will distinguish the products and services of your enterprise from those of the other. It refers to a particular enterprise which offers the product or services on the market. It refers to a particular quality of product or service for which it is used. And finally, it promotes the marketing and sale of products and rendering of services. In this picture, you can see too many logos. These logos, by seeing the logo itself, you can easily recognize the company. This is not descriptive. This logo will, the moment you see this logo, you can tell this is Hyundai. The moment you see these four squares, you can tell this is Microsoft. And this logo, by the same distinctive I, you can say it belongs to ICICI Bank. So this is the power of trademark. This gives you the brand name as well as easy recognition for the customers to use the services or the products of this company. Who can apply for trademark? Any individual, company, or a legal entity claiming to be the owner of the trademark can apply for the registration of trademark. The application for trademark can be filed, and within a few days, the owner can start using the symbol TM. Once the registrar of trademarks registers the trademark after due procedures and make an entry in the trademark registry and issue the owner the registration certificate, then only the owner can use the symbol round R, which means registered trademark. And in India, the registration of trademark is governed by the Controller General of Patents, Designs, Trademarks under the Ministry of Commerce and Industry, Government of India. The trademarks are registered under the Trademark Act 1999, which provide the trademark owner the right to sue for damages when any kind of infringement of trademarks occur. The validity of the trademark is normally 10 years from the date of filing, which can be renewed from time to time. And this is the process. If you file the application, immediately an application number is allotted to you, then it is forwarded to the examination. And once the examination report is issued, if any objections are received, then the owner will be asked to reply to the objection, and a show cause hearing will happen. If the owner claims, or if the owner proves his authenticity, then it will be accepted for registration. If not, the registration will be refused. In case during the examination no objection is caused, then directly it is accepted for the registration. And once it is accepted for registration, The details of the trademark will be published in the Journal of the Trademark of the Government of India, and again, some opposition is expected. If there is no opposition, then it is registered and the person will enjoy the benefits. In case if it is opposed after seeing the gazette notification, again process will happen whether to give the trademark to the owner or not after due procedure. I have registered my trademark and it is a registered trademark of my company. Someone has copied my trademark and indirectly stealing my business. What can I do? In what way these laws will help me? The trademark infringement is nothing but mere violation of the exclusive rights attaching to a trademark without the authorization of the trademark owner or with any license. The trademark infringement mostly occurs when a person uses the trademark, which may be either a symbol or a design which resembles the product owned by the other party, using deceptively similar marks, falsifying the marks, or using unregistered marks cause infringement under the Trademark Act. The owner may begin a legal proceeding against the party which infringes its registration, and the trademark infringement offences shall be punishable with imprisonment for a term of minimum 6 months, but which may extend to 3 years, and with a minimum fine of ₹15,000, which may extend up to 2 lakh depending upon the infringement. Next right is the copyright. Copyright is exclusive right an owner gains for his literary and artistic creations such as poems, novels, music, and paintings, etc. There is no formal registration process required in order to obtain a protection, but we have registration process. The copyright protection arises automatically on the creation of the work, provided it is original. If a person gets a copyright, the copyright owner can prohibit or he can authorize for some benefits that their works be copied or reproduced in any other form. He can distribute to the public in copy format. This will also give privilege to perform in public or broadcasted or used online. Only with the consent of the copyright owners, the work can be translated into the other languages. But if the person who uses without the knowledge of the copyright owner proves that he had used it only for personal or educational purposes, then there will not be any infringement. In case someone wantedly cause infringement to the copyright owner, these 3 types of remedies are available. That is civil remedy, then criminal remedy, and administrative remedy. Next one is geographical indication. Geographical indication originated from a definite geographical territory which is used to identify the agricultural, natural, or manufactured goods having exclusive special characteristics from a particular region. The GI confers a legal protection for specific goods of a region from unauthorized use of the same. This promotes economic prosperity of producers of goods in a geographical territory by boosting export. This picture shows you few products that have got geographical indications. The Tirupati Laddu, Madurai Malli, Palani Panjamridam, Channapatna Toys, Darjeeling Tea, Dharwad Peda are few examples of well-known geographical indications that have been granted very recently. We have Laddu everywhere in India, but Tirupati Laddu has an exclusive taste, an exclusive fragrance, aroma, and that's because of the technique used in Tirupati. Similarly, we have so many jasmines available all over the world, but this Madurai jasmine has a unique scent with it, which it has acquired from the water and soil of the regions of Madurai. Similarly, we have this peda everywhere, but the Dharwad peda is something very unique to, which has very unique taste and unique ingredients. So you cannot use this name like Dharwad peda for a peda which is produced in Kolkata, or you cannot use the name Darjeeling tea for a tea which is grown in Tamil Nadu. So this name gives a global presence and a global recognition for these products. So who can apply for GI registration? Any association of persons producers, organization, or authority established by or under the law can apply for GI registration. The applicant must represent the interest of producers. The applicant should apply on the prescribed format to the registrar of geographical indications along with the prescribed fee. And this tag, the GI tag, is valid for a period of 10 years, following which it can be renewed. GI tags are covered under the law of the World Trade Organization. Next comes the industrial designs. It refers to the right granted in many countries to protect the original, ornamental, and non-functional features of a product that results from a design activity. These rights concern merely the appearance of a product and not the product itself. You should not confuse the industrial designs with patents. Patent is the product itself, whereas designs, it is only the design, that is the mere appearance of the product or a 3D design. It allows the owner to exclude others, that is, it can the owner can prohibit others from making, importing, selling, hiring, or offering articles for sale in which the design is embodied. And where you have to file, if you have an idea, industrial idea, you can file at Kolkata. The branch offices are at New Delhi, Mumbai, Chennai. And what can be registered under industrial designs? Original designs. Then designs which is not new as such, but with new application. And it should not have been registered anywhere in the country. Who can apply? Any person, assignee, legal representative of the proprietor can apply on behalf of them. Next comes the patent. First of all, dear students, I would like to tell you one thing. Don't think that patent is something which is a science related or only scientists can have a patent. Anyone can have a patent. There is no eligibility for acquiring a patent. Only thing is you should have innovative, unique, novel idea. Your unique, novel, innovative idea will get you a patent, and your patent will get you crores and crores of money. Please believe me. A patent is an intellectual property right granted to an inventor by a country's government as a territorial right, usually for 20 years. There is no concept called international patent. Every patent is territorial based. Every country has its own patent law, and the patent granted in a country is purely governed by the respective country's patent law. And if you want to protect your invention in too many countries, then you have to apply for the patent in the respective countries, and you have to get. And there is no concept called international patent where you apply for a single, no, you apply through a single application and you get protection in all the countries. No. Then, this patent gives the owner the right to prevent others from making, using, importing, or selling the invention without permission. The inventions must be kept confidential to be patented and must be capable of industrial applications. If you have got some idea, you have invented something, can you patent it? Yes, you can patent it, provided your invention possesses all these four important criteria. It should be novel, it should be inventive step, that is, it should be non-obviousness to someone else. Only you can do it, or anyone can do it with the inputs what you have mentioned in the schema. Then it should have industrial applicability. Why industrial applicability? If it does not have industrial applicability, then no one will come and get your patent. Then it should be a patentable subject matter, because the government has something called non-patentable inventions. So that should not fall under non-patentable inventions criteria. Yes, I have an idea. It is innovative, it is unique, it is inventive, and it is not an obviousness. Whether will I be able to patent? No, if it falls under these criteria. The non-patentable inventions are very clearly given in the Section 3 of the Indian Patent Act 1970. A few are mentioned here. Section 3A says frivolous inventions are not patentable. That is, an invention that is frivolous or that claims anything obviously contrary to the well established. For example, if someone claims or if someone says a machine gives more than 100% performance, then even if it is true, that will not be given patent. A perpetual machine, that is a machine that does not stop once started, it will not be granted patent. Section 3B says inventions which are contrary to law or mortality or injurious to public health. For example, the genetically modified mouse, which are given some medicines to develop cancer, again for the purpose of medical research, are not patentable because the cancer can be transmitted to the public. Section 3D says mere discovery of a new form of a known substances or mere discovery of any new use of a known substance, process, machine or apparatus, unless such known process results in a new product, are not given patent. For example, the new use of aspirin for heart ailments. Already we are using aspirin for anti-inflammatory and for heart-related problems. But if you prove or if you invent a new use of aspirin, it is not patentable because already people are using aspirin. Similarly, mere new use of a neem tree. We all know neem is antiseptic and it provides antibiotic property. But if you invent a new use of the same neem, it is not patentable. So I have an idea that fulfills all the criteria for a patentable invention, and that does not follow or does not fall under the non-patentable inventions. If I can, can I patent? Yes, you can patent if you follow this process. So you have to file a provisional application. If you are confident enough that it is not available anywhere, you can directly go for complete application. But normally it is advised to go for a provisional application, because if you apply through complete application, you cannot edit. If you go via provisional, you can edit anytime. So once you file the patent, it is published in the Gazette of the Indian Patent Office promptly after 18 months. Between before 18 months from the filing date, then you have to request for the examination, and it is normally done within 48 months from the filing date. And after the thorough examination, the first examination report is issued, and it is third-party representation is expected. If there are any objections of all kinds to be complied within 12 months, if there are no objections or if the objections are very ignorable, then they will grant you the patent. In case the objections are serious, then the appeal will the appeal will be granted, and in front of the controller of patent, the hearing will happen. And as the owner of the patent, you have to justify your ownership and the novelty or whatsoever objections raised. And if the controller is satisfied with your claim, he will grant you the patent. In case if you feel the controller is biased, then you can go and appeal at the appellate board, and appellate board is the final authority who can revocate the patent or can ask you to amend the patent or dismiss the appeal. That is, they can grant you the patent. And this is the website of Intellectual Property India. It is very much friendly, user friendly, and you can get all your doubts clarified in this. So these are the IPR, various forms of IPRs, which anyone, even not necessarily a commerce student, any student should know. But as commerce students, you have to know one more thing called Indian Trademark Agent Examination. We have the Indian Patent Agent Examination. The reason why I have not spoke about that is, to become a patent agent, you can be an inventor, you can have too many patents, but you cannot become a patent agent, because to become a patent agent, a basic degree in science or engineering is must. But the Indian trademark agent, anyone can become an Indian trademark agent, and the trademark agent is one who specializes in trademark matters, Trademark agents are supposed to have extensive knowledge about trademarks and also should be adept at the process of registration and protection of trademarks as well deterrence of the usual fraudulent marks. He deals with all possible legal aspects of trademark right from its registration to the appearing for the court cases relating to trademark. What are the primary duties of trademark agent? He can help companies to select new trademark for their business. He conducts trademark search so as to ensure that the chosen trademark has not been already registered. Then he will assist in the drafting and filing of trademark applications for the registration of new trademarks and provide legal support for the same. And if you become a trademark agent, what are all the advantages you get? You are certified by the Indian Patent Office, Government of India. It is an added qualification and your name will be displayed on the Indian Trademark Registry website. You can work as independent consultant or work in MNCs, law firms, business houses for trademark filing, drafting, and working in coordination with the trademark office. I've finished my slide. I would like to have a discussion or more of interaction. Before that, I thank most respected General Secretary and Correspondent Sir, respected Principal Sir, respected Vice Principal Madam of Guru Nanak College for motivating me all my academic endeavors. I thank respected Head of the Department and faculty members of the Department of BCom Accounting and Finance, Guru Nanak College, for giving me an opportunity for sharing my views on IPR. Last but not the least, dear participants from from Guru Nanak College and various institutions all over the country. Now I would like to answer your questions and I expect more questions. Over to Ajita.
Yes, sir. Thank you. Thank you so much for your amazing session, sir. It was short but very informative. So this is the time for us, guys. If you have any doubts, questions, please turn on your mics. And even if your video, it's okay. So yeah, you can shoot.
Sir, can I ask my first question to begin with?
Yeah, please, ma'am. Please, ma'am.
Okay. My question is, where do you find the notification for the examination for Indian trademark agents, sir? Where do I find that?
It is available. The website I have mentioned, Indian Patent Agent, Indian Patent Office website, and periodically they give the notifications for Indian Patent Agent, Indian Trademark Agent, and every year it is announced. Mostly the exam happens in the month of June, July, madam.
Okay. No, if they have to go to the IPR website, right?
IP website. Indian Patent Office, IP website.
IP, Indian Patent website. They have to go and find that.
Yes.
What is the kind of knowledge that is required to prepare for this examination, sir?
Actually, they should be 21 years old. So normally they finish their degree by 20. Maybe they can spend 1 year for preparations. But I've told, but it is not easy to clear those examinations. It is equivalent to something like your CA exam or your ICWA exam. It is the process of selection is very stringent. You should have a prior knowledge about the Indian Trademark Act 1999. Thorough, you have to be fully thorough in that act. And the paper 2 gives you the drafting of trademark, if someone comes with a logo, how you advise them, how you have to draft the application. And as far as the applications are concerned, there are 2 types of applications. That is one application. One is the search. Before going for the application, you can be double confirmed whether your logo is unique or it is not available anywhere. So you can do a trademark search. They call it as TM search. And in TM search, they have so many classes. Nearly 52 classes they have. Whether which sector you want to search. It is sector specific. Whether it is automobile, whether it is IT, whether it is beauty, beauty parlors, whether it is production, manufacturing, whether it is services, hospitality, hospitals. So the searches are done mostly based upon the sector. So if your logo is unique in that particular sector, then you can go for the application. So you can save money, because normally the search you have to spend 500 rupees, but for the application you have to spend 5,000 rupees. Without searching, if you go, then you may lose if a similar mark has already been registered. So first one is search application, second one is the actual application. And these trademark agents will be very vital during those process for a layman who wants to register her or his business. It is similar, it is very similar to, it's my own property, but if there is any litigation cost, I cannot go directly and, defend myself in the court of law. I need an advocate. Similarly, as far as these IPRs are concerned, we need these agents, either patent agents or trademark agents, to go to the IP office and defend on behalf of ourselves and get those things. And I would like to tell you that it is not an exaggeration. Those who clear this trademark agent exam, or as I told you, you can practice on your own as independent consultants, or the MNCs are paying you a minimum of 12 lakhs per annum salary for being appointing as a trademark agent. But it is really, you have to prepare.
Sir, my question is not answered. My question was, they have to take up the examination. You also added one word saying that it's very tough for students. Now, because when they are going to clear a CA or a CWA, they will definitely go to the Institute of Cost Accountants of India and Chartered Accountants of India. Likewise, where are they supposed to go for extra coaching, or how do they prepare? Because it's an ocean.
There are a lot of trademark attorneys available in Chennai. They are giving coaching for this, and the actual thing is paper 1, Indian Trademark Act. They should be thorough in Indian Trademark Act. Second one thing is drafting of a trademark application, and third one is the interview. So coachings are available, and in the websites, and a lot of online coaching are also available. After this pandemic, we've got a lot of advertisements related to coaching for trademark agent exam and patent agent exam. A lot of websites available.
So instead of going for this examination immediately after degree, do you advise them to take up some diploma degree and then come back to this examination?
Yes, ma'am. They can go. But again, many companies are, it is again like civil services. Even if they fail, even that is taken as an experience, and some companies prefer those kinds of candidates.
So in MNCs, like in what role they would fit in, sir? Because companies they have already had patent, right? They already have the logos and everything. So
yeah, they will be under the IP portfolio. The patent agents as well as trademark agents will be totally governing their trademarks, and they will be entrusted with the work, like whether anyone is infringing their work, or whether they have to be in constant touch with the industry, and they should protect the company's trademark and patents. And you'll be surprised if I tell an Apple phone which cost around $650. Any Apple phone which costs $650 in the market actually costs the company only $220 for the manufacturing, and the rest goes for the IP management. So because these people will be constantly, in touch with the industry, market, and they will be, and we have so many cases and judgments, related to trademark, and the Arasan soap, Achi Masala, Dindikal Talapa Katti. Dindikal Talapa Katti is the traditional one, and somebody called Dindikal Talapa Katte, they have used the Talapa Katti's, logo. And they went and fought in the in trademark office, and they've got. And very recently, the Apple versus Samsung case, it is again deals with the trademark. So finally, the Samsung was penalized for infringing Apple's trademark, and they had to pay $10 million as fine.
Would a degree in law be a necessity to?
It is not necessary, ma'am, but definitely it will be an added advantage. But again, I clearly mentioned Indian patent agent, Indian trademark agent. You cannot be called attorney. You can be called an attorney only if you have a law degree. But definitely, if you go for if you want to, set up a profession related to IP, then it is advisable to go for a law, definitely, but it is not necessary. Even the trademark agent exam or the patent exam does not mandatorily ask you to finish a law degree.
Okay, sir. So I have one doubt, sir. I mean, like, if I'm going to apply for a patent, how long will it take? The whole process will take, sir. How long, and what should I, consider? Like I should make a search if the logos are available, and what else should I consider before applying for a patent, and how long should I?
So if you have a novel idea, innovative idea, known to you only, then you can go file a patent. First thing. And for that, there are very legal terms available. I don't want to confuse with those legal forms, Form 2A, Form 6. There are a lot of forms. But you as a layman, I have an idea. Okay.
Yes.
So you have to write your idea in a paper, and you have to meet a patent agent. I'm not advising you directly. Only with the help of a patent agent you can succeed getting a patent. But definitely a professional will help you more easier to obtain a patent. So he will draft your application based upon your idea and its novelty. Easily, he will enhance your application. Then you have to file in the Indian Patent Office. A search will be done. You can do a search. If you are very confident enough, then you can directly apply. Then normally it takes to minimum 6 months to maximum 3 years for the patent to be granted. But from the date of filing, your privileged time starts. And normally a patent's validity is 20 years. And after the 20 years, it goes public. Because the 20 years is given to you to enjoy the monopoly. After 20 years, it should go to the public. That is the government's rule. So day one, for example, January 1st, you are applying your patent and the process will be initiated. But from day one, that is January 1st, you can claim that you have got a patent and you can approach companies to use your patent for some monetary benefits. For example, you may have a good idea, but you may not have the resources to make that more industry ready. So you can talk to some companies, you can talk to some industry who are into this field, and they will come and but the protection you have already filed. So those companies cannot copy that from you. You have filed it. You can talk to the company, and if the company feels it is really something innovative and will be helpful, then they can pay you some money and come into some agreement for use your patent for some money. And the main concept of patent is the owner can himself use that, or he can assign someone, definitely for money.
Exactly. Right. So also you told that if we are going to register the patent in India, it's only going to be applicable in India.
Yes.
So we have to So for example, if I am having an innovative idea and someone else in United States also has the same idea, so I'm applying here and he's applying there in that country. So he'll get the rights in that country and I'll get the rights in here.
Exactly.
So okay. But
to prevent that, we have something called provision is there, like PCT, that is Patient Cooperation Treaty. So many people like Ajita wanted to protect their invention, so they have approached the government, and the government has approached the World Trade Organization, and they have brought out something called PCT, that is Patient Cooperation Treaty. So and around 50 countries are party to that. So if you file a patent via the PCT, that is Patient Cooperation Treaty, protection is given in those 58 countries. But again, there is a fee, and you have to pay that fee, and which will be divided among the 58 countries. But normally that is done by companies like Samsung, Apple, Amazon, who have global presence. If I invent something for which is more related to my country, then I need not worry about someone copying the same thing in America. Normally. But the protection, you cannot stop people copying your protection from other countries. And there is still something have to be worked on that.
Right, right.
Good.
So,
One more question from my side. This enumeration, sorry, I'm not allowing others to talk, but the more you explain, the more I get doubts because I'm prompted to ask the question, because I think in a way it will be helpful for them also, because I'm talking from their side. You can take me as a representative of students. So one question, last question, I'm not interrupting. So we are having a lot of cases in the society happening, like all the storytellers or for the movies. In the movie field, you see all the persons who tell the story, script writers, they go to the directors, they tell their stories. So, and they say that they have stolen my story. You hear all these reasons. So, shouldn't there be getting a copyright of their story and then approaching? Don't you think this would be the ideal solution?
And actually, in fact, I would like to tell about the Ilayaraja versus SPB case also. I think since it is everybody will be interested. But before that, I'll answer ma'am's question. Ma'am, anyone may have any, may get any idea, and the problem with copyright is it is not registrable. You can register, but it is not like mandatorily it should be registered. One thing. And it says that when the moment I get some idea and I write on a paper, that I acquire the copyrights. But even if some director, steals away a story of an assistant director or a storyteller, and we have seen cases, judgments are given in the favor of the story writers and the assistant directors, if they can prove their claim. If they can prove that I have done this on this date, maybe an email, I would have sent an email to someone, or I would have sent even some WhatsApp messages. So it is the trademark and the copyrights are normally done. If you prove the case for your stand, then finally the judgment is given in your favor. But there is one more movie where I don't know the name of the movie. Prakash Raj and Prithvi Raj. It will be the story of the Prithvi Raj, the hero Prithvi Raj story in that film. And Prakash Raj, he would have written in a book, and Prakash Raj will steal that book and he'll go and register it in the Copyright Society. And he would have, with that, he will become a hero also. But when Prithviraj comes to know about that, and even if he goes and file a petition in that producers council, they will say this has been registered. You cannot, do anything. So, and if someone voluntarily does that, we cannot stop that. But if you want to protect your rights, it is always advised to go for a copyright protection under Copyrights Protection Act 1957. And this Ilayaraja and S. Balasubramanian case, the music director acquires the copyright. The moment he, puts some tune, he gets the copyright. And Ilayaraja did not have any problem until it is used by me or you. We daily hear the music, we use in our car, and we sing in our school competitions, college culturals. He has no problem. But when S.P. Balasubramanian approached our agency to organize an event abroad, and for which they have earned millions and millions, and did not ask his prior permission to use. So then he went on court and he sued them. So if a person, and that's what I've put in my slide also, if anything is used for personal use or for fair use, for teaching, educational use, the owner cannot, sue them. But if I'm going to use your copyrighted material, and if I'm going to make money, then definitely you can sue me.
Sir, one question. I have been reading about music playing in restaurants and hotels, sir. So it's music which is playing there, and they are not getting money directly for the music they're playing, but it enhances the environment and everything.
Definitely.
So should they pay, or is there anything they have to subscribe?
No, they did not pay. They did not pay.
Okay.
If they did not pay, if the music is played to entertain the customers, and their main motto is to serve them food, and along with that, to keep them entertained, they use the music. If the same restaurant is going to say, advertise, we are, playing Ilayaraja's music, and you can come here, sit here, listen to that for half an hour, you will be charged 100 rupees, then he should get the permission.
Okay.
So if that music is a primary service, it is infringement.
Even if it is a primary service, if they are charging for that particular service,
okay,
then he should pay the royalty to the owner, or else he need not pay.
Right. Good. So I have one last question, sir. So I feel like, many people will get random ideas here and that. I mean, maybe unique, some might be, okay, this is already existing. But many don't take that step to take it to a patent, like we need to get the rights for it. So, like, how should they analyze, is my idea worth it? Should I take it to the next step? Like, what would you say to the students or to everyone? Like, is this idea...
To get a patent, if you are filing the patent on an individual's name, it is 1,000 rupees. Okay, and if you are applying on an organization name, 8,000 rupees. And I'll tell you, if it is really worth enough to get being granted as a patent, and once it is granted a patent, you can earn in crores. Can't you spend 1,000 rupees? So, but with this internet age, we cannot tell that we cannot analyze something. If something is a new idea, see, we know we are all using electrical appliances, and that works on the current. And when current goes off, what we will do? But someone has thought, why can't these current be saved and used for next few hours? That's how inverter came. So again, it is necessity is the mother of invention. If you have a problem, and if you see the other dimension of the problem, you get to know the solution for that. And if you scientifically analyze that solution, then it is patentable.
Sorry to interrupt. Can you give an example? Because I know many of our students doing a lot of promotions, and they're helping startups, like helping social networking sites like Twitter and Insta. They're all helping. Many of my current students and past students, they're all doing that job. So in what way can you explain one idea where they can make a patent, like helping the Instagram to promote their website? My students
actually, all software.
Can you give one the live example?
Yes, ma'am. All software programs, they cannot be patented. They can be only copyrighted.
Okay.
And in Instagram, Facebook, they can, if they're doing a business, some e-commerce business, then a trademark is very much important. But patents, if the idea, again, in patents, we have two types. One is process patent, another one is product patent. So very recently only the process patent were given importance. So until 1900s, only the product are given patent, not the process. But many copy the process, and a lot of cases happened, and then only they said, okay, we are giving process also patent. So you would have tasted coffee everywhere, but a particular restaurant's coffee has a unique taste. Even Coca-Cola, we have so many colas, even Pepsi and Coke are literally, look, taste, everything same. But there is some unique difference between both. And this is called trade secret, not patent. Actually, this is called trade secret. But again, this has some uniqueness, some innovativeness that is done by the inventor. Similarly, your students, if they feel it is very unique, the approach is very unique in selling a particular product, then that idea can be definitely patented. Because he is giving you a way to others, telling them, if you use this way, you will go to that particular place where you want to go very easily. So that idea can be patented.
Okay. So for an idea, we don't have to need a prototype or anything. We just need
never.
Okay.
That's what I'm telling you. If you get an idea, just write in a paper.
Right. Okay.
Just write a paper, and you can go to the IP office also. There is a help desk there. You can go to the IP office and tell them that I have got some idea. and I want to, and you can very well say, I don't want to go to a patent agent.
Okay.
Then they have a help desk. They will be diverting you to some people, so they will be helping you in drafting your patent application.
So is there any age limit to get a patent? Like even a teenager can get a patent if he has an idea, or?
No age limit.
Okay.
No age limit to get a patent. That's what I'm telling. There is no eligibility. There is no age. Only you should have an idea that is unique, novel, innovative, and it should have industrial applications. Because see, if I'm going to say I've got an idea, and if it is not industrially viable, okay, because you should not think why he's telling a commerce person, a non-science person can get a patent, but again, why he's using industrial. If I get an idea, I can patent it, no problem. But when I can make money out of it, only people comes and use that. And when people will come? Only if it has an industrial application. Only when you can make 1,000 crores of copies of your idea into products, then he'll get money, and in that he'll give you money.
Got it, sir.
And in Pondicherry, again I'm talking about my subject, but it is again in Pondicherry there is one person called Venkatachalam. So he has bred over 200 varieties of Kanakambaram. 200 varieties, and in papers you would have read he has developed more than 1,000 varieties of guava. Very recently he produced one guava with orange flavor and named it Modi guava. And he has and he has created a guava with chocolate taste. If you eat that guava, you will get chocolate taste. Apple, grapes, blueberry in guava. He has made more than 1,000 varieties, and he is not even past 8th standard.
Wow.
And he is a Padma Shri now. So it is in Pondicherry. That research institute is in Pondicherry. So it is mere idea, and no qualifications required.
So all these kind of now you have told us about this kind of a patent, sir. The persons who have acquired patents, trademarks, that list, will it be available in this IPR website?
Yeah, madam. Yeah, it is available. The list of granted patents it's there in the patent office.
No. Will it be like we're sitting at home? Can we see through the?
You can see the list of patent granted for the year 2019-2020. You can see the list. In that list, if you go, the detailed description of the invention will be given.
Not only patents, it will be containing all the trademarks and copyrights.
Everything will be there now. Everything will be there.
Yes, sir. This is a new knowledge for all of us too.
Yes, ma'am. Actually, many of you would have known, we've got an IPR cell in our college, which is inaugurated on March 2020, mainly to facilitate our students and faculty. And the convener of the IPR cell is Dr. J. Jayanti, our Dean Research Madam. So any students, faculty, if you have an idea, you can come to the IPR cell of a college and you can talk to us in person, where we will be facilitating you till you reach getting your patent. We'll help you. The IPR cell is always open, and anytime you can come and you can discuss your idea with us, and we will help you definitely to get a patent, trademark, and the other even in your place, if your place is very known for some product, then you can help those farmers or the producers also to get the GI, geographical indication, because I cannot sell an halwa with the name Tirunelveli halwa, which is produced in Chennai. If you see that initially in Chennai we have so many halwa shops with the name Tirunelveli, but again a person who has fought for the GI tag of Tirunelveli halwa came to the IP office and he filed the case. And now if you see, wherever they use the word Tirunelveli halwa, they'll use a subtitle like daily it is coming from Tirunelveli.
Okay.
So they'll tell that this halwa is not prepared here. If I prepare an halwa here, I should not name it as Tirunelveli halwa. Because they claim that This Tirunelveli halwa attains that taste because of the mineral content in Tamraparani water and the techniques in the preparation of the halwa, and they've kept it as a secret. So you prepare a much tastier halwa here, but don't claim it as Tirunelveli halwa. You claim it as Chennai halwa or Madipakam halwa, not Tirunelveli halwa. That is the power of GI tag. See, even here we have laddus which resembles Tirupati laddu, but you cannot call them Tirupati laddu. Only laddus produced from Tirupati Devasthanam only can be called Tirupati laddu because they have got the GI tag. And this Madurai Malli case is very famous. You cannot call jasmines from Dharmapuri or somewhere Salem as Madurai Malli because the Madurai Malli has a unique scent. And they claim in that application, they have claimed that it is because of the minerals that are available in Madurai and that Vaigai river and not anywhere else. And Dindigul lock, you have locks everywhere, but this Dindigul lock has got a patent because they say that we only have some mechanism and it is 100% foolproof, but it will look very bigger, but it is 100% foolproof. So this is a very powerful thing and it will definitely help these farmers, because if you want to set up a store here and if you want to use the tag, you are giving business to someone there.
Yes, sir.
From that area. So even we can help you in that GI also. So you can anytime contact Dr. Jayanti ma'am for your IP needs. We will be definitely we are waiting to help you.
Thank you, sir. That sir will be really profiting. I mean, like now we have the cell, we have the website, we have everything. We just need to think and get an idea. And
definitely you need to think. And if you come to us, we will tell whether it is, as you said, as Ajita asked, we will tell you whether it is patentable or not. So you need not waste time on that. You can go for a next invention.
Okay.
And in patent, there is one more clause which I did not mention. Mere rearrangement of our existing invention can also not be patented. For example, if you use umbrella with a fan, it is not patentable because fan is a separate entity, umbrella is a separate entity. You are just rearranging it. It may be useful for your business. If you have an umbrella fan, maybe your business will be boosted, but you cannot ask for patent. Or you cannot stop others from using your patent. The main idea of patent is you can stop others from using or copying for your item. But if you invent or if you release in the market an umbrella fan, tomorrow someone will do that. And you cannot stop that.
Okay. So anyone else having any doubts?
Student, I expect more answers. Because first time I'm addressing commerce students. Usually we'll address more, life science and the science students. But I'm also a little eagerly waiting.
I think this is a common topic that everybody can discuss because anyone can be a creator. Anybody can
That's
think of
very well said. Very well said. Anyone can become an inventor. You don't need science degree. You don't need a big science lab like we see in films to go for patent. No, it is mere idea and your critical thinking. If you think someone, you can have, when a person who did not pass 8th has nearly, that Venkatapati has 150 patents to himself. 150 patents.
Wow.
So anyone can become a creator and you can mint money, I'll tell you. You can mint money.
Okay. So this office is in Chennai. It is near Gindi only, right?
Yes, ma'am. It is very. Our college is blessed. In fact, we are more closer to that IP office. It's in Gindi. So anyone can go to the IP office. They have a very well-established help desk. And before going there, you can go to their websites, and all your queries will be answered. And in case you can go and visit them also.
Anybody having a question? If you can pose your questions.
So I have one question. I don't know if it's appropriate, but let me ask. So, okay, so Madurai Malli is having GI tag here. What if someone in some other country is using, will the government help to protect the rights from here to there?
Definitely. GI is global. That's what I would have,
okay.
I have clearly mentioned in my slide. The rules of GI is governed by the World Trade Organization. And that is not country specific. Only patent is country specific.
Right. Okay.
Okay, only patent is country specific. Even trademarks, it is not country specific. Because trademark is not registerable. If you can prove your seniority in using that, anyone copies anywhere, you can sue them. And similarly, GI tag also, it is mutually agreed by all the countries of the WTO, World Trade Organization, and they will respect this. So GI cannot be used anywhere without the prior permission of the. It is again not using the prior permission. If you ask the person who's holding the GI, he will tell you, you give us order, we'll export. That's all.
Right.
You don't need to do. It will be the taste or fragrance or the quality only we can produce. If you want, we will give you. You give us business.
Right. I have one more question.
1 minute, Ajita. Since we are talking about GI, why don't you, sir, tell about, if you could enumerate about that Odisha Rasagulla, Odisha versus West Bengal Rasagulla case?
Yes, ma'am. So again, that this Odisha versus West Bengal Rasagulla case, actually it was for the West Bengal only. Because they say again a particular variety of cow, and that quality is not achieved while we prepare rasagullas from milk from other variety of cow. And everywhere use rasagulla, no problem. But you cannot use Bengal rasagulla somewhere else. And they say that cooperative society who prepares that rasagulla can only use Bengal rasagulla, and nobody else can do that. Because even we have our Tanjavur Veenais got GI tag, and the Tanjavur, that doll, dancing doll, they have got a GI tag. But we cannot use Mysore's Chennapatna toys here. Mysore's Chennapatna toys is different, and Tanjavur dancing doll is different. So you cannot use the name. Actually, in fact, for business, name is more important. And many one goes for by the name only, not by the product.
So one question about GI as well. So a small village is having a really good product, but they are not registered with the GI tag. But in some other, like in Chennai, they're using the product with the same name, with the village name, take it XYZ product. So this village is oblivious, they don't know what's happening there. But someone has noticed, okay, someone is using our village name and they're making money there. So they did not register here in this village. Will they still be claiming, will they can be claim, because they have not registered already. So they can claim or what?
Yeah, I got your question. Actually, here, the farmers who are actually doing did not register. Someone else somewhere using the name. So you want to know whether the farmers can stop that?
Exactly. Yeah. Exactly.
Yes, they can do it. First thing is, even if they have not registered, someone from Mysore will not be given a GI tag for a product that is in Tamil Nadu. Because I've told you who can be an applicant. If you want to register, who can be an applicant, or not an individual. Only group of farmers, group of agriculturalists, group of association doing that particular occupation can only register. So this person from outside is not eligible to get registration. First thing. Second thing is, these people did not register, and he can use that, no problem. But the moment they notice that someone is using their name, okay, they can go to the GI, immediately file a GI application, and they can get themselves the GI. So till that is granted, he can use. They cannot stop that.
Right.
But the moment they get the GI tag, immediately they have to stop.
Right. Okay.
So, great, sir. It was an excellent explanation. Yes, you took the point from that slide and explained it. It was really beautiful. I was very impressed. Sir, if you could, because since there are no questions, since you know about all the cases on IPR, why don't you tell about the USA, United States of America, and haldi, that turmeric powder, that case.
Ma'am, actually that we have so many cases, ma'am. And we can talk, really I'm telling you, we can talk for hours together, and really we can talk for hours together because, all these are real problems. You're not talking about fantasies, or you're not talking something about in books. Everything is there, like turmeric, neem, as Azadecta indica. Neem case is very famous. Basmati rice is very famous. Okay, so this turmeric, again, two scientists from Indian origin. They were Indians. They went to United States, become a scientist there, and they were working for some companies, and that are the company's main portfolio is working some antiseptic. So these people, there is a compound called curcumin, that is the active ingredient in turmeric. So they used this curcumin and they have developed two products and they have patented, and the US government has given patent. But again, you should keep one thing in mind. Patents, definitely they are exclusive rights. The patent owner can enjoy, but it can be revoked. It is not irrevocable. It can be revoked anytime by the government. Very recent Covaxin and Covishield, the vaccines for the COVID-19 infection. You know what? The Bharat Biotech and Serum Institute of India, they tried applying a patent, but the government said no. Because if they are given patent, if they are granted patent, so they may cost they may price a single shot for 10,000 rupees. So the government said, no, we are ready to buy from you. We'll give you business, but we cannot give you patent. It is up to the government to decide. So here, this curcumin case, it is revocable. It is revocable. For that, I quoted this example. So the US patent has, they call it as USPTO, United States Patent Trademark Organization. So like we have IPO here, they have USPTO. So the USPTO has given patent for the curcumin, active ingredient curcumin, for healing wounds. Then our people, we have a body called CSIR, Council for Scientific and Industrial Research in India. So they came to know about this and they filed an objection for that. But the patent has been granted. So they claim that the turmeric, which has this curcumin, is being used in India from time immemorial for the healing properties. So they quoted a lot of, we have all our literatures and ancient scriptures for this, for the proof, and the patent was revoked and it was cancelled. And similarly, Basmati also, one company called Rice Tech, they have filed a patent for patent in the name of, they have filed a trademark in the name of Rice Tech, Basmati, and it was granted. And they said, since trademark is not territory based, they said no one in the world can use the word Basmati hereafter. Again, our people, they gathered all the evidences and they said the word Basmati came from the locals from between Pakistan and India, and they say this rice Basmati gains its texture, its length, and its fragrance because of the minerals that are present on the Satluj and Sindh river. So they first applied GI for that, and with that evidence, they asked the USPTO to revoke the patent, and it was revoked. So now anyone can use, but they said you cannot. But since the patent was granted, they revoked. But they said you can use Basmati rice like anyone use. You cannot use. You can use Basmati rice as the name of the product, not as your brand. So dates, we have line dates, we have anil dates, we have so many dates. So like the dates, you can use Basmati rice, but you cannot use Basmati as your brand name.
Got it, sir.
well explained, sir. Because
Yes.
why I asked you to explain, because since you are familiar with so many cases, I thought that students, they are very younger. So these were the cases that were, when they were all little more smaller, these cases would have happened. So if you just talk to them, they will also have a clear picture of the worldwide.
And many of the students here, they would have played that game called PUBG. So even that PUBG, that logo is now registered for trademark, and the person who designed that, he is getting more than $1 billion per year, $1 billion per year.
Right.
So this intellectual properties are not something which we can see from a distance. It is something which we use daily. Daily we use one product: the soap, toiletries, bike, notebooks, pen, mobile phone. Everything has IP with itself. The thing is, you have to properly, use that.
Okay.
And definitely you can use it for your own self also.
Sir, I have one last question, sir. It's just coming up as you explained. So, as you told that,
I guess we three would have, done this session.
Yes, sir. So you told that case about basmati, right? They can't use the word basmati. So can they vary the name? For example, basmati king. Can they put the name like that?
No,
because
they cannot.
Because I'm seeing a lot of tea shops having this chai king, chai wala, chai boss, something like that. So they are having this chai. It's tea. It's something.
But no one claimed as no one like basmati. No one has ever claimed chai. So it is a well-known thing. And in trademarks, again, there's one more concept called well-known trademarks. So Bajaj is not confined to one particular product. They have electrical appliances. They have automobiles. So like Wipro, they have more than 50 products. Not only IT, they have bulbs. They have toiletries, everything. So these brand names are called, they are called well-known trademarks, like Reliance. Reliance into many things. That R, a rounded R, it is into many things. Similarly, Adani, Wilmot Adani. So these are called well-known trademarks, for which you have to, again, even if you acquire, you have registered it as a trademark, you have to again make one more application to use under well-known trademarks. So again, it has its own privileges and advantages.
So can I relate this well-known trademarks to Amazon? Because Amazon is there, Amazon Pantry is there, Amazon music is there.
That's what.
Right,
Normally, we say for trademark represents a business, a definite business. But these well-known trademarks can jump into too many areas with the same name. That is again a goodwill, because it is not because they are into automobiles. We go by because it is Bajaj.
True.
So again, the goodwill of the company matters. So and again, everyone who claims for a well-known trademark will not be granted well-known trademark. Again, it has its own procedure, and only after do that, they will do that.
Okay. Got it, sir. Anyone else? One question from the audience. Or you can say how informative this session was. Anything from you guys.
If someone can unmute yourself and give me a feedback, whether it was good or bad, and anything, I'll be very happy.
I think people are thinking about their own ideas right now to approach you.
But as I said, you please come to our IPR cell, and you can contact Dr. Jayanti Madam, Dean Research, Guru Nanak Center for Research, and we will be definitely helping you.
So definitely, you will get a lot of flooding requests from now on. And it was such an enthralling session, because you patiently explained about so many things. And very importantly, it was very practical and a very interactive session, because only talking from the slides, that will not help us, sir. Only when you tell us how they have to practically go and apply, where they have to go for assistance, all these kind of real guidance will help them to really think about getting some kind of trademark or copyright for their own ideas or for their innovations. So it was very, very informative. And I think when we had a discussion also, you told me that you have a lot of inputs for when they venture into e-commerce also, what they have to do for getting their trademark.
Yes, ma'am. I'm actually, now I'll be very happy to do one more session on exclusive e-commerce.
Exactly, I was trying
because
to
since it was, we discussed yesterday, I could not use much of that here. There is an the IPR for e-commerce is a special and an exclusive field.
Okay, so I think we should be running a webinar. It should be a FTP or not FTP, not for faculties, but it should be a series of webinars or whatever it is, so that we cover everything unit-wise and understand in totality of how this trademark and the copyrights can be useful for us for all other fields. Whether you're doing traditional marketing or you're going online, how it would be useful. I think we will definitely think of arranging other sessions.
Yes,
so that you can.
I would love to do that.
Yes, sir. Yeah, so I will hand over the mic to Ajita. Really thankful because I don't know whether the students have understood or not. I think that as Ajita said, they should be thinking, oh, I have got an idea, so this is also a viable one, commercially viable.
True.
This should be a new news for them. It should be
True.
so. And I will hand over the mic to Ajita, thanking
Yes,
you nicely from the bottom of your heart, sir.
Thank you so much, sir. I feel so, like if I'm having an idea, I could easily approach someone, and I think the idea won't go in vain. So like also for the examination, I've never known or heard about it. So also for the website, so I think I'm gonna check it out after this webinar. So thank you for that, sir. It was really informative. I mean, like in 1 hour, I got a lot of inputs. So that's what I could say. Thank you so much, sir. So now I request Amula ma'am to render the vote of thanks.
Good evening. No matter what language you speak, a kind and smiling thank you always speaks to everyone's heart. Good evening, everyone. I am Amuda Lakshmi and I am here to present the vote of thanks for today's webinar. Let me first of all thank the Almighty, the Creator, for the bottom of my heart for making today's occasion as a most successful event. For this, we are so blessed and thankful to God. I would like to thank our chief guest, webinar speaker, Mr. Mahendra Kumar, Assistant Professor, Department of Biotechnology, Guru Nanak College, Chennai, for enlightening us with his knowledge. Today's webinar was full of knowledge and interesting things. It gives deep insights into the topic and also reveals so interesting facts. The point where Mr. Mahendra Kumar sir told about the IPR was really informative. I was really pretty sure that precious knowledge that Mr. Mahendra Kumar sir said.
Thank you.
And gave us definitely help our students to be in future. I extend my heartfelt gratitude to our General Secretary sir, Sardar Manjit Singh Nair, for his support and providing us an opportunity to explore our talents. A warm thanks goes to our Principal sir, Dr. M.G. Raghunathan, for his enthusiastic support. We express our immeasurable gratification in thanking our Vice Principal Ma'am, Dr. N.C. Rajeshri, for his providing support to us. I extend our sincere thanks to our beloved Head of the Department, Ma'am, Dr. Gayatri Harikumar, for briefing for his introduction of his chief guest of the day. I would also like to thank all the professors of our department for encouraging the students to participate and also guiding to them. I special thanks to Satish sir and Arun sir for Viscom department for live streaming our program through our college YouTube channel. Finally, in the end, I would like to extend my wholehearted thankfulness to our illustrious students who always cater the needs of our expectations and who are the pillars of our strength. Thank you.
Thank you so much, ma'am. So really, guys, I'm gonna post.
Really, it's very informative. That
Thank you, ma'am.
Laddus, Parani Panchamirtham and all, really it's
the tea time, so we're all remembering.
Yeah. Thank you, ma'am.
And full, really informative, sir.
Yeah. Hereafter, if you're gonna eat the laddu, we'll be thinking about the rice.
Is functioning
from Tirupati to Madurai, Malli to Parni, everything.
No, I know. Ma'am was enjoying. Amuda ma'am was enjoying the lecture.
Really.
Nowadays, whenever I see a product, I see with that angle only.
Yes.
What are all the IPs that has?
Yes.
So only when you think or when you see in that angle, you will be able to generate one, definitely.
Yes, true, sir. Thank you, ma'am.
Thank you, sir. Thank you.
Okay, ma'am. Thank you so much, ma'am. So,
Thank you.
So, guys, I'm gonna yes, ma'am. I'll post the certificate link in the comment and you can check it. And there's this photo session right now. Guys, audience, can you please turn on your video so that we can take a picture?
thank you, Narasimha.
Guys, just for 2 minutes, turn on your videos so that we can take a good, beautiful picture. Guys, can you please turn on the videos? Thank you, everyone. Okay, so I'm going to capture the picture. So, cheese. Okay, ma'am, I got it. Thank you, everyone.
Thank you.
So we'll end the session with the national anthem. Do you have Vinodini?
We'll sing. We will sing.
Yeah, okay. Sing. Can you start, ma'am?
जनगण मन अधिनायक जय हे भारत भाग्य पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जल जल तब शुभ नामे जागे जब शुभ गाहे जब शयनाथा
जन भारत भाग्य विधाता
जय हे जय हे जय हे
जय 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 हे.
Thank you, ma'am.